Good morning. It's day 5 of London International Disputes Week, and welcome to this session from a rather dark and wet Cambridge. I hope that it is drier and brighter where you are. Last night it occurred to me that a plausible analogy with the world of economic sanctions was plate tectonics. Bear with me. Global, ever-changing, advancing, colliding, diverging, overlapping. Problematic, to put it mildly. I'm joined this morning by a geographically diverse and complementarily expert panel. First is Susan Leddy, who is Senior Legal Counsel at Swiss Re in Zurich. And Susan is an insurance and reinsurance contract specialist. She therefore has a uniquely sector-specific take on sanctions issues. Artem Zavaronkov is a partner at Borenius law firm in St. Petersburg. He may appear in just a moment. I can now see Susan. And Artem practices in corporate, antitrust, banking and financial law, as well as cross-border M&A transactions for Russian and international clients. He has extensive and recognized expertise in the field of economic sanctions. Ben Wells is a partner at Candy in London. He specializes in international dispute resolution, including fraud and asset recovery. He's a fluent Russian speaker, and a great deal of his work is CIS related. Now, last and very much least, I am a barrister at Radcliffe Chambers in Lincoln's Inn, and I do pretty similar work to Ben. But unlike Ben, I do not speak Russian, and I fear that at my advanced age, that may not change. Now, economic sanctions are instruments of foreign policy, and therefore primarily, or at least initially, they are matters of politics and of economics. But of course, they require legal expression and effect. Now, today we're going to talk about the private law consequences of economic sanctions, and in particular, their effect on the enforceability of contractual obligations and the adjudication of disputes about those obligations. And we're going to do that primarily, but not exclusively, as you'll hear, by reference to English law and procedure. Now, we aim to leave a bit of time at the end for questions. And if you have any questions, could you please use the Q&A function, which ought to appear on your screen in the usual place. Now, the first thing we're going to talk about is the subject of sanctions and contractual obligations. And I thought I might begin very briefly with a sketch of the general law. Now, the imposition of economic sanctions, which prohibit the performance of obligations under an existing contract, may make that contract or that obligation unenforceable because of something called supervening illegality. Now, whether that's a species of frustration, as has long been generally supposed, is nowadays a matter of some controversy. But that's a question that can have important consequences. And there are lots of reasons for that, but just a couple of them. I mean, frustration is a crude and far-reaching remedy, if it is a remedy. And amongst other things, it causes the discharge of the contract, even though the sanctions which trigger it may only be temporary. Another factor is that the need to demonstrate frustration may also make the affected party's case harder to prove, given the stringent requirements of the doctrine and the long practice in the English courts of keeping its application within narrow bounds. Now, whatever the precise analysis, in every case where supervening illegality is alleged to have been caused by economic sanctions, the court will always very carefully scrutinize the legal prohibition which is relied on and the terms of the contractual obligation which it is said to affect. And it will not readily conclude that a party is relieved of its obligation to perform. So what laws are relevant? Well, since the 1st of January 2021, the only sanctions with direct effect in England and Wales are those which apply under the UK sanctions regime. EU sanctions are now therefore foreign sanctions, but the performance of international contracts is obviously capable of being drastically affected by foreign sanctions. So when will the English courts give effect to foreign sanctions? Well, English law doesn't generally excuse contractual performance by reference to foreign law, unless it is either the law of the contract or the law of the place of performance. Now, illegality under the law of the place of performance is often called the rule in Raleigh Brothers, and that's a case in the Court of Appeal a century ago now. And there are, at least formally, some lingering unresolved questions about the Raleigh Brothers rule. One of them is whether it's a part of the English law of frustration, or it's a conflicts rule, or indeed that it's something else. There are also questions about whether it applies to subsisting as well as to supervening illegality, and also whether it applies only when the governing law of the contract is English law. Today, we're not going to try to resolve those questions, but what is clear is that the rule adopts a strict view as to the place of contractual performance, and importantly, ignores what may be essential preparatory acts elsewhere. And the rule also necessarily requires an act in the place of performance, which is unlawful in that place. Now, the problem, of course, is that there may be other foreign sanctions which are not relevant under English law on any of these bases, but which may yet have a very serious effect on one of the parties. Now, hitherto, and I suspect for some time to come, the chief concern in that respect is going to be United States sanctions. Now, US primary sanctions apply to a US person, anyone operating in the US, or anyone dealing with property which is subject to US jurisdiction. Now, even such primary sanctions have obvious extraterritorial reach. Even more problematic are US secondary sanctions, because they purport to apply to everyone else and amount to an assertion of global jurisdiction, which often cannot be ignored, however objectionable it might be, because of the economic might of the US, and in particular the continuing status of the US dollar as the world's reserve currency. Now, all of these considerations suggest that express contractual provision dealing with the incidence and effect of economic sanctions should be included in international agreements which may be affected by them, because in that way, arguments about common law illegality and frustration can be avoided, and all of the sanctions under whatever law they might arise, to which a party may become subject, can be made contractually relevant. Now, an appropriately worded force majeure clause might be effective to relieve a party from liability for non-performance by reason of sanctions, but a specific sanction clause is much more likely to produce certainty of outcome and better risk management and allocation. At least that is the theory. How hard can it be? Well, we're now going to move on to talk briefly about three recent-ish cases which illustrate some of the issues and problems. Now, the first is a decision of the Court of Appeal in a case called La Mesa Investments Limited and Synergy Bank from the middle of last year. Now, this concerned a Cyprus company, La Mesa, which claimed interest due to it from an English bank, Synergy, under a sterling-denominated loan agreement subject to English law and jurisdiction. Now, after the agreement was concluded, the Russian ultimate beneficial owner of La Mesa became a specially designated person under US sanctions relating to Ukraine, and La Mesa thereby a blocked person. Now, Synergy resisted payment on the grounds that it would otherwise knowingly facilitate a significant financial transaction in breach of US secondary sanctions, and become liable in particular to, and I'm just going to share my screen now, I hope. So they were particularly concerned that they were going to become subject to this prohibition, so in other words, in relation to the opening or the maintenance or conditions on the maintenance of a United States correspondent bank. And that was a potentially serious problem for Synergy because it operated just such an account for the purposes of its US dollar business. Now, it didn't suggest that the general law, which I described a moment ago, allowed it to resist payment, but it relied instead on a clause which provided that it would not be in breach in relation to payments of sums if such sums were not paid in order to comply with any mandatory provision of law, regulation, or order of any competent court, of any court of competent jurisdiction. And there was also a fairly extensive definition of the word regulation, and one can see that that purports to have fairly general and apparently international reach. But one of the points to note was that neither the non-payment clause or that definition clause refer specifically to sanctions. Now, Synergy nonetheless succeeded in the commercial court, and La Mesa appealed. And the Court of Appeal dismissed that appeal, and it did so for a few reasons, which I'll describe briefly. Now, first of all, the court thought that it was crucial that the clause did not purport to extinguish Synergy's repayment obligation. As the court said, of course, a clause could do that, but very clear wording would be needed. Rather, this clause only suspended that payment obligation. Another thing the court said was that a mandatory provision of law simply meant one that was compulsory, one which imposed a requirement or prohibition. Now, the court thought that the literal wording of the clause, and I think particularly the words "not paid in order to comply," suggested that it applied only where the non-payment was directly required by the legal provision in question. But the court thought the words were not clear. And in construing them, it relied on 3 points. The first was it said that the clause was in a standard form found in a number of finance agreements. Well, one might have one's doubts about quite how standard it was, but it certainly hadn't been individually negotiated between the parties to this agreement. Another point of significance was that the courts considered that the parties should be taken to have been aware of the terms of Article 5 of the EU blocking regulation, which provided, and it's on the screen there, that no person shall comply, whether directly or indirectly, with any requirement or prohibition resulting directly or indirectly from the laws specified. And they thought that was significant in the context of an agreement where, at the time it was made, US secondary sanctions would have been one of the problems which the parties might have thought that they would face. So the court held ultimately that the non-payment clause meant that a borrower would not be in default if its reason for non-payment was to comply with a foreign statute which would otherwise be engaged. And that was especially true because the blocking regulation regarded US secondary sanctions as imposing a requirement or prohibition with which EU parties were otherwise required to comply. Now, the next case is a case decided a few months later called Banco San Juan International and Petróleos de Venezuela. Now, this was another US sanctions case, this time involving a Puerto Rican bank, which brought claims in relation to the failure of Venezuela's state-owned oil company to make payments, repayments under credit agreements, which had been concluded after the US imposed economic sanctions on Venezuela in 2014. Now, in very broad terms, the sanctions, so far as they were said to affect PDV, so the defendant, blocked various property in the United States where they emanated from or they were paid by a person who was a designated person or affected by the sanctions. Now, PDV alleged that its payment obligations were suspended by a clause which provided that it would not repay loans with the proceeds of, and there are two things. First of all, business activities that had become subject to sanctions, restrictions, or embargoes imposed by various US bodies, or the proceeds of business activities in or with a country or territory which had become subject to sanctions. And they said that Venezuela was one such country. And so their argument was that all of its business activities were sanctioned and all of its proceeds from which they could make the repayments were ultimately derived from its business in a sanctioned country, in other words, Venezuela. The judge, admittedly on a summary judgment application, and so we don't have as much detail about the contract or indeed about the judge's reasoning as one might otherwise have. But the judge decided that the clause that we looked at didn't suspend PDV's payment obligation. Indeed, it made no mention of suspension. Instead, it was a merely negative covenant for the bank's benefit rather than some condition or qualification to the accrual of the payment obligation. And it was significant that that payment obligation was dealt with in the contract quite separately elsewhere, and there was no reference to it in the sanction clause. And the sanction clause effectively, so the judge held, gave the right to the bank to refuse to receive a payment which was made in breach of that clause, as well as a right of recourse in relation to such a breach. And the judge also thought that PDV's obligation, both under the agreement, but also under the general law, to obtain all licenses necessary for its performance, also suggested that the payment obligation survived in a sanctioned situation. Now, before moving on, I should mention, I mean, PDV had lots of arguments for trying to resist payment. And another one was reliance on the rule in Raleigh Brothers. And briefly, that involved their arguing that since the account into which they would make the payment, if they were to comply with the contract, or the payment obligation of the contract was in the US, it could not perform it in accordance with US law. Now, the judge couldn't decide that question because there wasn't any evidence of US law before her. But the licenses point, which I've already mentioned, became relevant here too, because it was common ground that it was open to PDV and indeed the bank to apply to for a license from OFAC to allow the payment. But, and the judge thought that in fact the obligation was on PDV to do so, but not only had it not done so, but it hadn't adduced any evidence that if it had done so, such a license would be refused. So on that ground too, or on that ground, the Raleigh Brothers rule was not available to it. Now, PDV relied rather loosely on the La Mesa case as justification for non-payment, but it also relied on another slightly earlier case from 2018 called Manon Cochet Mining and Aegis Managing Agency Limited. Now, that was an insurance case, and so I'm going to hand over to Susan to talk about sanctions in that industry, as well as that case itself. Susan.
Thank you. All right. Now, I will now attempt to share my slides. What is the reinsurance industry doing about sanctions clauses? And before I turn to talk about the Manon Cochet case, I think it might be helpful to put a little bit of context. Up on screen is a very typical sanctions clause seen in international insurance and reinsurance contracts. And in my experience, these clauses have been really fairly standard since around 2012. Although, as you can see from the bottom of the clause, it was actually issued in 2010 and was issued by the Joint Hull Committee in the UK as being appropriate for marine business. The clause has really three components. The first couple of lines making clear what's not going to be provided, so no cover, no liability to be claims or provide any benefit, and then going to the core of the clause that if the provision of the cover or the payments or provision of the benefit would expose the insurer or reinsurer to then a number of listed sanctions regimes. And I don't know whether the Joint Hull Committee were being particularly prescient back in 2010 while they included UK sanctions. Obviously, there have been UK sanctions, separate UK sanctions for some years, but obviously now post-Brexit, these have much greater significance. So the question then is, well, why is it that the insurance and reinsurance industry became so keen to have these clauses in? I mean, Chantal has talked about, the advantages of contractual certainty, but there was a fairly clear push from the regulators to do so. And here I've just put a couple of points, perhaps for people to bear in mind. We've already talked briefly about OFAC, Office of Foreign Asset Control, the unit in the US Treasury, which was responsible for sanctions implementation and enforcement. And back even as far as 2007, they were making the case that for international insurance, it was advisable to include a sanctions clause. Now, obviously, this was tied to US sanctions, but the clear steer there. And then more recently, 2015, Lloyd's in London issuing guidance that really it's considered to be a good underwriting practice to have this kind of clause. And that has certainly been embraced by the industry, which takes us to the Manon Cochet case. And obviously, everybody being busy putting these clauses in their contracts, there's some uncertainty as to how these are going to play out in the event of a dispute. So I think certainly within the industry, when the Manon Cochet case came out, a great deal of interest. I'm not sure at the end of the day the case is so determinative, but let's turn to the facts. So what do we have? Back in 2012, a cargo insurance covering a shipment of some steel billets going from Russia to Iran. The billets arrive, the original purchaser declines to pay, so they have to find a new consignee. The billets end up in a bonded warehouse and they're stolen at some stage in the autumn of 2012. Manon Cochet makes a claim in early 2013, and underwriters, of whom there were 11 on the placement, it was obviously not uncommon to have a range of insurers, And what's important to note is some of these insurers were foreign subsidiaries of US companies. And in 2013, it appears the position was taken not to deny that there was a valid claim that these billets had been stolen, but rather that the claim could not be paid because of sanctions. And the clause in issue was the one we just looked at briefly, the LMA 3100, the Joint Hull Committee clause. So by the time the matter came to trial, which was not until 2018, quite a lot had happened in the Iran sanctions space, as we're probably all aware. When the loss occurred in 2012, there were in fact no sanctions which would have impeded payment. But later, foreign subsidiaries of US companies were made subject to US primary sanctions on Iran. We then in 2016 had the JCPOA, the Joint Comprehensive Plan of Action, when there was effectively a reduction in the sanctions, EU sanctions largely in relation to Iran removed, US sanctions greatly reduced. But then, of course, in 2018, President Trump withdrew the US from the JCPOA. And at the time of the trial in the autumn of 2018, it was known that come the 4th of November 2018, US sanctions would effectively be reimposed, which would of course cause a problem for the underwriters who were the subsidiaries of US-owned companies. So where did this end up with the judgment? There are really three key components that were of interest to us in the industry. The first was the question, when the clause referred to exposure to sanctions, did it actually mean that there was an exposure to the risk of sanctions, or did it mean that it meant that if payment was made, it was prohibited, that effectively that was the exposure risk? And the judge found, which I think was not so surprising, that some generalized concern about risk of sanctions was not going to be sufficient to trigger the clause and allow reliance. The second aspect, obviously, was consideration, well, if the underwriters paid, was it actually prohibited? Was there a reason then to trigger the clause? And there was extensive evidence given, experts called by both sides as to what the position was on US sanctions. And the ultimate conclusion was, I think perhaps slightly ironically, given how long this case had been going on for, was that as of October 2018, there was no prohibition on the underwriters settling the case. As of the 4th of November 2018, there would be. So they were not entitled to rely on the clause. And there was also, just to mention sort of some obiter comments about the EU blocking statute, Mamonche raising that as a potential counter-argument that, in fact, the insurers could not rely on the clause or deny payment, because to do so would be contrary to the EU blocking statute. And that point wasn't really developed in the judgment because it didn't need to be, though the judge made some slightly interesting comments about, well, reliance on a clause would be acceptable and would not be in breach of the blocking statute. And what I put here on this final slide is some of the sort of the issues that we look at with clauses, even now, sort of post Mamonche, is the preference is to have clauses which relate to talk about exposure, not violate, because we like to look for broader language. That violate is considered to be a bit narrow. Obviously, we have to consider which sanctions regimes are in scope. There are a number of clauses in the industry which just talk about applicable sanctions, rather than being so specific. But of course, you know, we now have the new beast of UK sanctions. There's the blocking statutes. The EU blocking statute, which impacts Iran and Cuba. We now have the UK blocking statute, which effectively mirrors the EU blocking statute. And then, as I guess, as just sort of a coda, there's the German anti-boycott law, where we have issues if you refer in a clause to sanctions regimes which are not directly applicable in Germany. So with that, maybe I hand back to you, Shantanu, if you want to add any comments or not about Maman Cochet, or we then head Russiawards.
Well, we will go to Russia. Sounds very exciting, doesn't it? But I just thought I might, just picking up on the Maman Cochet case and how it fits into the kind of general territory in terms of sanction clauses. I mean, so far as I'm aware, but I'm sure be corrected rapidly if I'm wrong, I think Maman Cochet is the first and only case where the English court has dealt with the effect of the blocking regulation on sanctions clauses. And of course, it didn't decide anything because the judge didn't have to. But I confess that I was rather puzzled by it. And it's not clear whether the judge was saying, and I don't know, Susan, whether you have any views about this, whether the judge was saying that if you can rely on a sanction clause, whatever it says, then that means that you don't collide with or breach the blocking regulation, or it depends what the clause provides for. And I don't know if you have any thoughts about that.
I think probably the former. I mean, there's comments in Obiter and not really sort of fully developed, but it seemed to be that if you had a contractual provision to rely on, what you were looking to do was give force to that contractual provision. So therefore there would be no blocking statute issue, which seemed interesting and quite encouraging to insurers and reinsurers, but I think we were left thinking whether actually if the point really had been argued, would it have come out that way in the end?
Yes, because I mean, you might say one of the consequences of that sort of reading would be that the blocking statute would never apply in a sanctions clause situation where the sanction clause actually applied. And I mean, unfortunately, it didn't arise in the Lemeza case because, of course, the Ukraine sanctions are not designated under the EU blocking statute, so there wasn't any question of it being unenforceable for that reason. But the wording which the Court of Appeal relied on as being resonant to the blocking statute in the Lemeza clause would, you might think, be a very good reason why it should be taken to mean that it was contravening the blocking statute. But anyway, we'll have to wait for another case to find out. But I think I would just wrap up before moving to rapidly on to Artem with, I suppose, just drawing attention to the many difficulties that even these cases demonstrate in relation to the drafting of sanction clauses. I think what very careful thought needs to be given to trigger events. What is it, as Susan has indicated, which gives rise to the right to resist payment, because that's usually what it will be. The question whether the sanctions are terminatory or discharging events. And one sees some very extreme clauses in certain industries. I mean, there are certain BIMCO clauses which give rights not only on the non-sanctioned party to terminate, but even to claim damages. And there are clearly tensions at work, I think, or at play, in trying to be sufficiently specific to cover all relevant sanctions regimes, including US secondary sanctions, but also future-proofing, because as we're about to move on to discover, the sanctions world is changing all the time, and there are new players. Now, Artem, Russia has been, I think, fairly candid about its inability to fight fire with fire in terms of imposing economic sanctions on anyone else which are likely to have much effect. But you're going to tell us about something the Russians have done in order to evade the effect of sanctions, and particularly US sanctions.
Yes, Shantanu, thank you. Yeah, there's been some kind of interesting development in Russia lately on sanctions-related basics, and yeah, let me share at full screen, yeah, I'm going to be talking about specifically two new clauses in the Russia's commercial arbitrage procedure code. It's a document describing how you should proceed in a commercial court. This is all about procedure, and namely, it's dealing with the exclusivity of Russian courts over certain sanctions-related cases. Okay. So first of all, it's section 249.1 that states that Russian commercial courts may have exclusive competence in respect of two sub-matters, which is first of all disputes involving sanctioned persons. And I'm wrong here. The document does not use the word sanctioned Instead, it uses the wording like restrictive measures. So it's a broader definition. So if restrictive measures includes pretty much any type of sanctions. I believe it's not only SDNs, specially designated nationals. It's not only prohibited. It's also sectoral sanctions. It's also secondary sanctions. So territorial sanctions like Crimea-based sanctions or something like that. So one, keep in mind that it's a broader competition. And so that's the one precondition. And second precondition is that the exclusivity of a Russian court might apply if there was a dispute based on sanctions against Russia. So even a non-sanctioned party may initiate a dispute, a proceeding in a Russian court if the merits of the case are indeed based on the sanctions provisions, on the Russia program sanctions provision. Again, I add, if there was a North Korea related sanctions, you might not be able to initiate court proceedings in Russia or Iran related or something like that. So it's specifically Russia related restrictions. There's one more interesting thing, which is that the exclusive competence also applies in case, for example, you already have a contract, okay? You have already a non-Russian arbitration clause or litigation clause in another jurisdiction, and still a sanctioned person or subject to restrictive measures, whatever, may initiate, may invoke that exclusivity clause in case it is able to prove that the Russian party has been denied access to justice in other jurisdictions. And I'm going to be talking about that later on a little bit. So the second new article of the Commercial Procedure Code is that a person may request a Russian commercial court to issue a ruling to prohibit or to abort a sanction-based proceedings in a non-Russian commercial court or arbitration tribunal. That's a completely entirely new provision of the law. There's been no relevant practice so far, so it's difficult to say what kind of outcome is going to follow out of that provision. But still, the bottom line is that a Russian counterparty may now initiate a proceeding in a Russian court aimed at prohibiting or aborting or terminating completely the opposing legal proceeding in a non-Russian court. Okay, and there are two relevant court cases lately. So just very briefly. The first case is Uralvagonzavod. That's the company. It's a Russian company. I guess it's involved in manufacturing of railroad cars. That's hence the name. Versus a Polish company whose name I have difficulty pronouncing. Whatever. So the UVZs, let's call it UVZ Uralvagonzavod, they initiated proceeding in a Russian court based on that 248.1, stating that there's been proceeding going on, arbitration proceeding already in place at the Stockholm Arbitration Tribunal, and the UVZ was claiming that it should be stopped or terminated completely because of that provision on exclusivity. And the Russian court decides against that claim because, first of all, the dispute between UVZ and the Polish counterparty has already been taken place in Stockholm, and UVZ has not been denied to attend the meetings and so on and so forth. And more importantly, the merits of the case are exclusively purely commercial ones. It's a non-payment, a contractual non-payment, and those merits are not based on sanctions provisions whatsoever. That's why the Russian court has ruled that there's no possibility for the court to apply the new exclusivity provisions. Okay, then there's another more interesting case, which has been quite politically exposed, so to say, which is Tsargrad Media versus Google. Tsargrad Media is a TV channel, and I think the beneficiary has been included on either US and EU sanctions, SDN sanctions lists. And in 2020, Google, and it did have a Google account and many services. It had subscription to many Google services, and Google in last year, Google just closed its account and terminated all the subscriptions, so on and so forth. Tsargrad Media filed a claim with the Russian court, citing once again 248.9, and indeed there are three defendants in this case: Google Russia, US, Google California-based Google, and Google Ireland. And there are agreements with any of them. My understanding is that there's an agreement between Tsargrad Media and Google, stating that all disputes should be subject to resolution by the courts, the competent courts in either California or Ireland. And despite that provision, the Russian court decides that it does have exclusivity over the case indeed, because you guess what? Because Tsargrad Media has been denied access to justice in either the United States or Ireland. Well, I haven't seen the documents by myself actually, but the way it's been described in the public domain, I understand that there's been a letter from the law firm called Steptoe and Johnson, and Tsargrad Media asked them to represent them in that proceedings in either US or Ireland. And what Steptoe Johnson says in that letter, my understanding, I haven't seen the document, but the way it's described in the court materials is that the firm states that, okay, it doesn't say that we cannot represent you in either the United States or Ireland because you are a sanctioned person. No, it doesn't say that. Instead, it states that, okay, guys, it's just too much hassle representing you, because we have to be registered with OFAC, the US sanctions regulator. We have to provide reports within 10 days after every accounting period of the types of work done for you. Then we have to report on the fees received by us from you. So it's too much hassle and it's not good enough. We're not interested in that. Thank you, but no. But that letter has been served as the basis for the judge to say that, okay, Tsargrad Media has been denied justice. And that's why, the court has already held its session on the merits of the case and ruled in favor of Tsargrad Media. And one of the particularities of that case is that a hefty fine used to be paid by Google for each day of the court states that the account of Tsargrad Media must be reactivated, and all services must be reactivated. And if Google fails to do so within a certain period of time, it must pay a fine of 100,000 rubles each day, but that fine doubles each week of non-payment. And there was a journalist who calculated that if Google didn't pay for 2 years, then the amount of fine would be equal to the whole, to the actual value of the whole Alphabet group, including Google. So, well, it's not going to happen, I guess, but still, you know, that's quite an alarming notice. And that's my last slide. So what is this all about? What the fuss is all about? There's been a leading trend in the latest legal practice in Russia, which is that the bottom line is that the application of sanctions against Russians, against Russian companies or Russian individuals in Russia would contradict the public order in this country, and therefore the legal consequences that any action based on that would be null and void. Okay, so that's the bottom line. And we've seen cases, the now infamous case of Siemens of 2018, where Siemens claimed that there was a funny story. There was quite a well-known story when the local subsidiary in my hometown of St. Petersburg manufactured 4 high-capacity gas turbines for a Russian customer, and that Russian customer immediately after, you know, the manufacturing process has been completed, resold that gas turbines to a third party, and then the gas turbines, in fact, reappeared in Crimea. Siemens filed a claim stating that, among other things, it is against the EU sanctions, and it cannot be submitted to Crimea, sure thing. But the court held that no, it's not the case, because the application of EU sanction, in this case, against Russian persons in Russia would contradict the public order. So we're all good. And that trend is leading now. And now the Tsargrad media case just confirms that trend. And the final goal, I understand that why it's been done. And I think it's clear that the final goal of that new piece of legislation is to eliminate every possibility for non-Russian counterparties to apply sanctions in Russia. You know, elsewhere you're good to go. You know, when it comes to UK sanctions, sure, you know, nobody can stop you applying, you know, sanctions in your home jurisdiction or elsewhere but Russia. So that's the bottom line. And that's pretty, you know, that's a big deal, actually, you know, and that goes, my message to our compliance colleagues is that, guys, you need to reconsider your approach. Well, at least, well, Russia-wise, you need to think about that, and you need to think about how to mitigate the risks out of those new developments in Russia. But that's entirely, how to do that is entirely different story. But you know, I would be happy to be part of that discussion if needed. And that concludes my presentation. Thank you.
Artem, thank you very much, not least for explaining how events in Russia have complicated even further the world of international sanctions. We haven't touched on China, and there's no time for that, but of course we've seen some quite controversial Chinese sanctions having been imposed on, in particular, people who have said objectionable things about China's treatment of Uyghurs, and it may well be in the years to come that as China's economic might increases, they will become serious players in the world of economic sanctions themselves. But closer to home, we've adverted once or twice already to another new player, and that of course is the UK, after leaving the European sanctions regime. And Ben, you're going to tell us something about that.
Yes, definitely. Good morning, everyone, and thank you for joining. I hope that I've shared my screen with you just now. And I'm going to be talking about UK sanctions. So, as mentioned by my learned friend, the UK sanctions regime is in force under the Sanctions and Anti-Money Laundering Act 2018, which is also known as the Sanctions Act. And this legislation has enabled us to transition existing EU regimes into the UK. And these came into force on the 31st of December 2020, and they're very much aligned with the EU sanctions. But in fact, they're a bit denser and more complex. The reason for that is because lots of the defined terms are held in the Sanctions Act. So in fact, to navigate through the new provisions, you need to have quite a few documents open at any one time. They very much impact all UK territory and UK persons, including UK nationals and UK incorporated entities. And what happens is that the UK government publishes a UK sanctions list. And that list provides the details of those designated under regulations made under the Sanctions Act. And it also includes details of which sanctions measures apply to which people. And in the case of UK designations, it provides a statement as to the reason as to why they've been designated to be subject to sanctions. As I'm sure you're all very aware, governments are increasingly relying on sanctions as a tool for political foreign policy. And new entities are added to and removed from the sanctions list all of the time. Over the past 5 years, the average number of designated entities has increased significantly. If you don't abide by sanctions, there are monetary penalties, and these are imposed for breaches where there's a connection with the UK. It's the Office for Financial Sanctions Implementation, or OFSI, which is responsible for ensuring that UK sanctions are implemented and enforced. The penalty threshold is reached where, on the balance of probabilities, there's been a breach and the person committing it knew or had reasonable cause to suspect that they were committing a breach, as well as one of the following conditions. So that the breach involved some funds or economic resources being made available to a designated person, or if there's evidence of circumvention. By making arrangements to circumvent the law, a person not only breaches the law, but also attacks the integrity of the system. Or if there's some other reason, so if OFSI believes that a monetary penalty is appropriate and proportionate, they can list that penalty anyway. There's also quite an important provision whereby if a person has not complied with a requirement to provide information to OFSI, that also causes big difficulties. And it's very important to answer any inquiries in a punctual and holistic manner. There's a set procedure by which they calibrate the value of the fine, then communicated to the wrongdoer, who actually has the right to 2 different levels of appeal. The first one is ministerial review, and after that, there's an appeal procedure as well before payment. When a penalty is issued, the details are then published to the general public. This is very important. Obviously, you want people to be aware of who are breaching sanctions, and so that the general public is aware of what's happened. There was such a penalty recently. It was actually under the EU sanctions regime, to which the UK was a part, and it was against Standard Chartered Bank in February 2020. In the amount of it in excess of £20 million. Now, this took place following the bank's voluntary disclosure of 102 loans made to DenizBank, which is a wholly subsidiary of Sberbank in Russia. And at the relevant time, Sberbank was subject to restrictive measures. And as DenizBank was Sberbank's subsidiary, the restrictions also applied to it. OFSI reviewed the situation and assessed that while some of the loans were permitted under an exemption, 70 of the loans weren't, and they had an estimated value of £266 million. So they looked at this. They knew Standard Chartered Bank was aware of the sanctions regime and that it needed to take compliance steps. In fact, initially, it had ceased all finance business with DenizBank when it became a sanctioned entity. So it was very clear it had been aware. However, they then sought to use dispensations enabling such loans to be made where they considered that an exemption was applicable. OFSI assessed that the dispensations were not appropriately applied, and the subsequent application of the dispensations enabled these loans to be made, which were not within any exemption and therefore in breach of the regulations. In this instance, Standard Chartered applied for a ministerial review for part of the fine, but it was upheld in full. So there's a real possibility that such fines will be imposed under the UK regime. In order for them to be applicable, there must be a UK nexus. So the UK nexus covers all individuals and legal entities in the UK territory. all UK nationals and entities established under UK law, including their branches, and also transactions using clearing services in the UK. So as you can imagine, this touches lots of transactions and it touches lots of corporate entities and individuals as well. As we've seen from the example of Standard Chartered, entities which aren't on a sanctions list but have a relationship with a sanctioned entity also present a really big risk. And what we're really moving on to, with regards to the differences between the EU and the UK sanctions, the UK sanctions have moved over more towards the 50% rule, which is used in the US. And this means that automatically, where there's a non-designated entity, so it's an entity not subject to sanctions, but it's owned or controlled by a designated entity, more than 50%, then there's an automatic asset freeze against that entity and a prohibition on making funds available without a license. The Russian sanctions regime has been enacted by the Russia Sanctions EU Exit Regulations 2019, and these also came into force on the 31st of December 2020. And these include sectoral sanctions on Russia, which very much, I mean, they largely mirror the EU sanctions. They have prohibitions on the sale, supply, use of goods and technology which have a civilian or military purpose. So those are the ones which were originally set out in Annex 1 to the EU regulations, as well as a prohibition on the sale of items which are suited to deep water or Arctic oil exploration and production without prior authorization, as listed in Annex 2. The only thing is there's quite a large difference between the UK and EU sanctions in this manner, because the UK sanctions require a license for all Annex 1 and 2 items, not only just for use in Russia, but also to any person connected with Russia. So that can include a whole plethora of additional entities and people who might be trading with Russia or have a connection with Russia. In addition, where there was an exemption for financing the import of goods between the EU and a third country, this has been mirrored with the UK, so it's possible to do that with the UK, but clearly a lot of countries have been cut out of that equation. So again, that condition has tightened quite dramatically. To conclude, overall, all businesses in all sectors are obliged to comply with sanction screening requirements, and therefore they need to have controls in place. Historically, enforcement actions have been more prominent in financial services, but this is changing quite rapidly. Other sectors have also received significant fines, and regulatory bodies are turning their attentions to other industries. Failure to comply with the sanctions or obtain the correct license in case of export controls can lead to significant fines. Enforcement agencies levy fines not only for violations of sanctions, but also for the failure to have adequate controls in place. So this means that firms need to really ensure they carry out effective sanctions screening, not only for direct third parties, but also for associates and beneficial owners, particularly in geographies known to have strong links to sanctioned countries. Companies also need to keep pace with the ever-changing sanctions landscape to stay compliant. To manage sanctions risks effectively, need to screen clients, both new and existing, and payment transactions on multiple sanctions lists. They'll also need to ensure of not falling foul of instruments abroad, such as the ones that Artem just discussed. It's important to take these considerations into mind as well, to ensure parties aren't falling foul of instruments, or that they're not able to rely on their previous dispute resolution clauses because they become subject to fines from other territories, such as Russia, which can be up to a very high amount of fine. I believe it's possibly up to the full value of disputes. So there's quite a few considerations for companies to take into account there. I'll pass back to Shantanu now.
Well, thank you, Ben. I mean, the new UK sanctions regime is a big subject, and there are obviously always dangers in trying to summarise it. And I think there are more than 30 autonomous sanctions regimes contained within the new, in inverted commas, UK sanctions regime. And although the UK says, and I'm sure intends, that it's the policy objectives of its sanction regime aligns with that of the EU. It is with some understatement, I think, on the OFSI website that it warns readers that they should not assume the EU sanctions regime is the same as the UK sanctions regime and vice versa. And you've already given a couple of indications about where that's true. There's some other things as well. I mean, there are differences in licensing procedures and also the sorts of licensing which are available. I mean, there's no general license available under EU law, but there is under the UK financial sanctions regime. And it's interesting divergence between attitudes towards the processing of payments. And that's that. I mean, I think the EU regime is that the processing of payments, which is a big issue for UK banking, is not caught by the EU regime. But it does appear to be caught by the UK regime. So anyway, lots of things to worry about if you're already suffering the headache of complying when it comes to international business. And doubtless there more divergences will be created or become apparent from the interpretation of these provisions once and if they get to court. Now, we have a number of questions, and I've been looking at them, but we haven't got very much time. I anxious to finish on time because I know that there will be other events that people who are watching this will want to get to for 11 o'clock. I'm very open to other members of the panel pitching in and answering some of them, but I thought just a couple of them I could possibly deal with. One of the questions we've had is whether frustration, it's possible to argue frustration, even if there is a force majeure clause in the contract. And the answer to that, and this is a general answer rather than one related particularly to sanctions, is yes. And there are various instances in the cases of parties who seek to be relieved of obligations to perform or liability under the contract, who argue that the force majeure clause in the contract doesn't apply, but instead the general law of frustration applies, and there will be any number of reasons why that might benefit the party contending that. And in relation to that, there's also another question about whether secondary, it says, would a force majeure clause, which only relates to government enactments, also without additional facts, also include reference to US sanctions? Well, at the risk of giving a weasel but predictable answer, it all depends. And you can see that it might be easier to say that a force majeure clause, depending on its drafting, applied to US primary sanctions than to US secondary sanctions. But of course, it all depends on quite how it's drawn and how it's drawn as interpreted in the factual context in which the parties entered into the contract. And if, like as happened in La Mesa, one of the things the court takes into account was the likelihood that secondary sanctions might apply to this contract at some point, then that will be something which will be taken into account in interpreting a clause which potentially relates to it. Now, I don't know if any of my fellow panelists have any observations about that, or there are any questions they think they have time and the ability to answer before we sign off.
Shantanu, I wouldn't have anything to add to what you were talking about. I've just posted an answer to the question which was raised about GBP and whether that established UK nexus. Yes,
good. And I'm sure we're all available offline if people want to continue the discussion or ask further questions. But we're getting towards 11 o'clock. And so I just wanted to thank everyone this morning who has attended and listened to us and watched us. I'd also like to thank my fellow panelists for very informative and interesting presentations, from which I certainly have learned a great deal. And finally, also to thank the many sponsors who I think you saw on the first slide when this broadcast began, of London International Disputes Week, which literally could not have taken place without their generous support. And I don't know how many of you have managed to attend other sessions, but it has been a remarkably diverse and successful week, it seems to me. And of course, we'd all rather meet in person, but the additional possibilities of doing it electronically have been fully realized, in my opinion. Anyway, thank you very much again, and good morning.